In this video, I am going to talk about the procedure for calling elections in the UK. This is now provided for by the Fixed Term Parliaments Act 2011, and this will be the main focus of this mini lecture. But I will also go into the situation as it was before 2011, as well as the similarities and differences between the British position and that of other Commonwealth and former Commonwealth countries. The Fixed Term Parliaments Act, as the name implies, establishes a fixed timetable for elections in the United Kingdom. But the Act also provides a couple of exceptions to the rule that elections happen on a schedule every 5 years. And in fact, of the 3 general elections that have taken place since the Act was passed in 2011, only one, the 2015 election, happened according to the timetable set out in the Act. The 2017 and especially the 2019 election were exceptional in terms of the Act. And in spite of this being legislation put forward by the Conservative-led coalition government, the Fixed Term Parliaments Act has proved unpopular with Conservatives. The Conservative Party manifesto for the 2019 election proposed the repeal of the Act. It says, "We will get rid of the Fixed Term Parliaments Act. It has led to paralysis at a time the country needed decisive action." And I don't mean to alarm you, but if the Conservative government were to simply do as it says exactly, to repeal the Fixed Term Parliaments Act, as a matter of law, it would never have to call an election ever again. I'll get to that later on, but first let's start at the beginning. Prior to the Fixed Term Parliaments Act, the timing of elections was under the control of government, subject to a statutory maximum term of 5 years. Legally speaking, the power to dissolve Parliament, to end the Parliament so that elections were called for a new House of Commons, belonged to Her Majesty. It was part of the royal prerogative, but like many of the prerogative powers, by convention it was exercised on ministerial advice. So in practice, the Prime Minister would ask to see Her Majesty at Buckingham Palace, and would drive there in the Prime Ministerial limousine to ask for a dissolution. Then he or she would drive back to Downing Street and would typically give an outside press conference announcing the election. As you might imagine, this gave a tremendous tactical advantage to the governing party in any general election. The Prime Minister or her advisers could keep their eye on the polls and could try to match the timing of elections to an upturn in his or her party's fortunes. The opposition, on the other hand, had to fight an election campaign at a time not of their choosing. There was some limit to this, in that there was a 5-year maximum term imposed by the Septennial Act 1716, so-called because the upper limit set by the Act was originally 7 years. This was shortened to 5 years by the Parliament Act 1911. But inside 5 years, the Prime Minister could seek a dissolution at any time, and Her Majesty would grant it. Now, you might think this is unfair, but the UK is not out on a limb compared to some other Commonwealth and former Commonwealth countries. An example that is extremely close to the British pre-Fixed Term Parliaments Act position can be found in Jamaica. Section 64(1) of the Jamaican Constitution says, "The Governor-General may at any time by proclamation published in the Gazette prorogue or dissolve Parliament." By subsection 5 of that section, this power is stated to be exercisable on prime ministerial advice, and alternatively if the government loses a vote of no confidence in the House of Representatives. As in the UK, the Governor-General, acting as the representative of Her Majesty, would appear to have no discretion in the matter. And as was the case in the UK, there the length of a parliament, that is, the time between elections, has a maximum limit of 5 years, as can be seen in section 64, subsection 2. Section 64, subsection 3 allows this maximum limit to be set aside in times of national emergency. This has been the practice in the UK too, for example, during the Second World War. Canada has a similar 5-year maximum period between elections. Article 4 of the Canadian Charter of Rights and Freedoms provides that no House of Commons and no Legislative Assembly shall continue for longer than 5 years from the date fixed for the return of the writs at a general election of its members. And as with Jamaica and the UK, there is provision for this period to be extended, as Clause 2 puts it, in time of real or apprehended war, invasion or insurrection. The position in Canada was very similar to the historic position in the UK. The Governor-General, or in the case of the provincial legislatures, the Lieutenant Governor, would grant an election at the request of the Prime Minister or Premier. But Canada has introduced its own version of the Fixed Term Parliaments Act. Under a 2006 amendment to the Canada Elections Act, elections to the federal parliament must take place on the third Monday in October in the fourth calendar year after the previous poll, unless an election is forced by the loss of a vote of confidence. Ireland and South Africa have, to differing degrees, set themselves a bit more clearly apart from the Westminster tradition. The position in Ireland is set out in Article 13, Section 2, which states that the Dáil Éireann shall be summoned and dissolved by the President on the advice of the Taoiseach. So far, so British, apart from the language, of course. But it then goes on to say that the President may, in his absolute discretion, refuse to dissolve Dáil Éireann on the advice of a Taoiseach who has ceased to retain the support of a majority of the Dáil Éireann. So real power is vested in the President, but only in specially defined circumstances, namely in the event that the President loses a vote of confidence. Article 49 of the South African Constitution states that the National Assembly is elected for 5 years, at the end of which the President must call an election within 90 days. Section 50 of the Constitution states that the Assembly may itself vote for a dissolution, but only after 3 years. This 3-year minimum term was intended to provide stability of government, which is far from guaranteed by South Africa's proportional representation system for choosing assembly members. Section 49 also tries to anticipate the possibility of an inconclusive or disputed election, instructing the President to call fresh elections if the Electoral Commission fails to deliver the results of an election, or if the election results are set aside by a court. I hope you will draw a couple of conclusions from this brief summary of the position elsewhere in the Commonwealth and former Commonwealth. First, the UK's position is historically not so anomalous, but second, Commonwealth practice shows a bit of variation as practice has evolved in response to particular circumstances, and even Canada has moved towards a fixed period between elections. South Africa has moved furthest from what we might call the traditional Westminster paradigm. But back to the UK, the unfairness of the government's ability to choose the time of elections had been the subject of debate for years. When the legislation was eventually passed, the Deputy Prime Minister, Nick Clegg, said, "For the first time in our history, the timing of elections will not be a plaything of governments. There will be no more feverish speculation over the date of the next election. Instead, everyone will know how long a parliament can be expected to last, bringing much greater stability to our political system. We'll see how this works out later." The Act, in fact, represented a compromise between the Liberal Democrat and the Conservative positions. The Liberal Democrat manifesto had set out proposals for a recall system, as the manifesto put it, so that constituents could force a by-election for any MP found responsible of serious wrongdoing. The Conservatives wouldn't agree to that, but a Fixed-Term Parliaments Act at least made it clear when a politician's term was at an end, and would hopefully prevent gaming of the election timing. So the Act set a period of a fixed term of 5 years, which was, on the face of it, not subject to political manipulation by the Prime Minister. The Act provided 2 circumstances under which an election could be held ahead of 5 years, and these can be found in Section 2 of the Fixed Term Parliaments Act. There was in fact a third way of calling a general election, not in the Act itself, and I will talk about that later. The first situation provided for by the Act can be found by looking at Section 2 subsection 1 and Section 2 subsection 2, which provide that where the House of Commons voted by a 2/3 majority of all MPs, that there shall be an early election. And by all MPs, I mean all MPs, not just 2/3 of those participating in a vote. The second situation is provided for by subsections 3 to 5 of the section, and arises where the House of Commons passes a vote of no confidence in Her Majesty's government, and if within 14 days no government has been formed and gained a motion of confidence from the House. The motion of no confidence requires only a simple majority to be carried. What is significant about these two exceptions is that they place the decision to dissolve Parliament not in the hands of the Prime Minister and executive government, but in Parliament itself. And unless we are talking about a vote of no confidence, there is a requirement of a supermajority. So even if the Prime Minister wants to call an election, in a typical Parliament this requires the agreement not only of the Prime Minister's own party, but of a substantial number of opposition MPs as well. And that, as far as the Prime Minister is concerned, is part of the problem. Theresa May, the previous Prime Minister, called for an election in 2017, and it is important to say called for rather than called, because as you will now understand, she could no longer just ask Her Majesty for a dissolution. But Prime Minister Johnson had a more difficult time than his predecessor. After he became Prime Minister in 2019, he failed 3 times to get sufficient cross-party support to call an election. This was frustrating to the Prime Minister because he didn't have a majority in Parliament for his Brexit deal, nor was there sufficient support among MPs for any other way out of the impasse. So that is the story behind the Conservatives' manifesto statement that it has led to paralysis at a time the country needed decisive action. In more strictly constitutional language, what you could say is that it created a danger of impasse or gridlock, to use the American term. A government that lacks the support for its policies in Parliament can lumber on, unable to pass legislation, but unable either to renew its mandate from the people or hand over power to a new government. But the Act also failed to take the decision as to the timing of the elections out of the hands of the Prime Minister, as we shall now see. After his third failure to get a 2/3 majority of the Commons to vote for an early election, under the procedure set out in Section 2.1 of the Fixed Term Parliaments Act, the Prime Minister chose a different path, which was to amend the law as set out in the Fixed Term Parliaments Act. This course of action had the advantage to the Prime Minister that only a bare majority of MPs had to vote for the measure, something that was achievable, although the consent of the House of Lords was required if the election was to take place straight away, as you will understand when you watch my lecture on the Parliament Act. In the event, the early Parliamentary General Election Act was passed with the approval of the House of Lords. The Act, which contained just 2 sections, completed its passage through the House of Commons in a single day, completed the Lords stages the very next day, and received royal assent 1 more day later, on 31st of October 2019. The Act does not actually repeal or amend the Fixed Term Parliaments Act as such. It merely provides for a one-off exception, which was for an election to take place on the 12th of December 2019, as a result of which, as most of you know, the Conservative Party won a large majority. But let us finally talk about repeal itself and the alarming thought that this might end the legal requirement for there ever to be an election again. As Lord Norton has pointed out repeatedly on his blog, The Norton View, Lord Norton is an expert on legislatures. The consequence of a straightforward repeal would be that there would be no legal obligation on the government to call an election ever again. This is because the Septennial Act 1716, as amended by the Parliament Act 1911, which provided the statutory maximum term of Parliament, was repealed by the Fixed Term Parliaments Act, So if that Act is now repealed, then there would be no remaining limitation of the length of Parliament on the statute book. On a charitable interpretation, though, what the government intends is not a straightforward repeal of the Fixed Term Parliament Act, but something more like a repeal and replace. One attempt at such legislation has already been attempted. A private member's bill, the Fixed Term Parliament Act 2011 repeal bill, had its first reading in the House of Lords in February 2020. But in any event, the government is likely to introduce its own legislation soon. But to conclude, I hope you have learned a number of things from this video. I have talked about the perceived unfairness of allowing the Prime Minister, the leader of one political party, to choose the timing of elections. And I have talked about the approaches taken by other countries of the former empire that have constitutions descended closely or remotely from our own. And perhaps more importantly, I have talked about some of the difficulties that have arisen in our attempt to fix the timing of elections in the United Kingdom. It is more than likely that the Fixed Term Parliaments Act will be repealed before long, but it will continue to provide an object lesson of one particularly thorny area of constitutional reform. I'll see you in the next video.